Thank you. Okay, members, the meeting is now open to the public. While we are now open, could I thank the Deputy Chairperson for chairing the meeting in my absence last week, and also I would like to thank Gemma for her service with us, because I'm aware that this is our last meeting with us. So thank you very much, Gemma, and thank you very much, Deputy Chairperson, for your work last week. Members, the committee is going to be recorded and broadcast throughout Parliament buildings and online. And we'll just wait for the public gallery to fill up. Everybody in the public gallery, you're very welcome to use your mobile devices as long as they're in airplane mode and everything is muted. You can connect our Wi-Fi and password details are available in the gallery rules. It's not permitted to take photographs or record any of the meeting, although dear knows why anybody would wish to. It's proposed that the oral evidence session with the Bar of Northern Ireland on the Justice Bill and the oral evidence session with the Department of Justice on the draft budget 2025-26 will be recorded by Hansard. Are members agreed?
Agreed.
Thank you. Members, also, as ever, we are obliged to declare any financial or other relevant interests that may reasonably be thought by others to influence our decisions or approaches to matters under consideration. Anybody who's got a declaration to declare in relation to today's business should do so now or when the particular matter arises in the meeting. Does anybody have any interest to declare at this stage? Deirdre?
Immediate family member who works in the court service.
And I have an immediate family member who works in the legal profession. It's always the two of us, isn't it? Agenda item 3 is draft minutes. So the draft minutes from last week's meeting, which was the 30th of January, are pages 19 to 26 of your pack. Are members content that those minutes are a true and accurate reflection of the proceedings of the meeting held on the 30th?
Yeah, agreed.
That's great. Then I'll sign them off. Item 4 is matters arising. Does anybody have any matters arising? I've got a couple here. If I could ask you to turn to pages 28 to 33 of your pack around this. The committee had agreed to share the update of the Enabling Access to Justice with the Bar of Northern Ireland, the Law Society and the Solicitors Criminal Bar Association. So following receipt of the correspondence, the Bar of Northern Ireland has requested an opportunity to provide oral evidence to the committee regarding the Enabling Access to Justice programme and the Criminal Bar Association's withdrawal of services. Could I ask your views then whether or not you're content to schedule an evidence session with the Bar of Northern Ireland on the Enabling Access to Justice programme? Are you content? I think it would be useful, as that's an ongoing situation. I think it would be useful for us to hear. So that's fair enough. We'll add that to the forward work programme, and the committee team will liaise with the Bar of Northern Ireland to arrange a suitable date, but it could be very, very soon. And we'll come on to that later, members, as we discuss the forward work programme. Item 4.2 is correspondence from the Department regarding the Enabling Access to Justice programme, and that's found at pages 34 to 37 of your packs. At our meeting on the 16th of January, the committee agreed to ask the Department a number of questions relating to the update on this Enabling Access to Justice programme, and this included a request for specific details of engagement with the profession, including that aimed at avoiding withdrawal of services, clarification of the date for the consultation launch and for the implementation of fee changes, and information on the time taken to pay legal aid bills. The Department's response can be found at pages 34 and 35 of the pack. We also agreed last week to ask the profession for details of engagement with the Minister and with departmental officials on these issues. Are members content to note the response from the Department at this stage, or do you require any further information?
Just a bit more, I suppose, detail. I know it was raised, obviously, at question time on Monday with the Minister, so just around the initial uplift, the 16%, and I know she had said around May time for some of the regulations to come in, but it's just when that would take effect, if there's any more detail. And I suppose the outcome of the engagement, I mean, we might hear some of it today in the oral evidence session, but of those engagements that she had on Tuesday, I think it was,
yes,
with the profession around trying to reach an agreement and trying to avoid any further action, if that's possible, by the profession. So just to get more of a specific timeline, if they have it, on when payments would take effect beyond the May kind of timeline that was given.
Are members agreed?
Agreed.
Yes, thank you. We'll come to that. I think there's a gap, and we'll come to it in the forward work programme for next week. People have withdrawn on the basis I think they want a bit of extra time, and that might be our opportunity to hear from the bar and the Law Society and or the Solicitors Criminal Bar Association, should they so wish to come and speak to us on the access to justice issue and the conversations that have been ongoing with the Department and the Minister, but we can come to that in terms of the forward work programme. So everybody's happy enough then? Yeah? All right. Agenda item 5 is the Justice Bill, and we're about to receive oral evidence from the Bar of Northern Ireland. I would ask members to turn to pages 38 to 55 of your pack for the relevant papers. So representatives from the Bar are in attendance and are moving forward to take their places now. I would welcome Donal Lunny, KC, that's force of habit, apologies.
Right.
KC, the Chair of the Bar of Northern Ireland, Denise Kiley,
Yes.
Thank you, Denise. KC, Vice Chair, and David Mulholland, Chief Executive, to the meeting. Thank you very much, folks, for coming. We appreciate you taking the time. We look forward to hearing what you have to say. We thank you for your paper in advance, and we look forward to hearing what you have to say with regard to elements of the Justice Bill. So I'm going to hand over to you, probably 10-15 minutes for a presentation, and then we'll move into a period of questions. Thank you.
Thank you, Chair, committee members. I'm going to start this afternoon, so good afternoon to you all. And can I start by thanking the committee for hearing from the Bar of Northern Ireland today on the important issue of the Justice Bill. There are several very important issues and principles in play, and the Chair of the Bar, Donal Lunny, beside me, who has already been introduced, and I will take you through those. As you're well aware, the Executive and the Assembly returned 1 year ago this week, so it's very encouraging to see locally elected MLA scrutinising an Executive Bill, and the Bar of Northern Ireland is very pleased to assist in the scrutiny process. We intend to concentrate our evidence around serious concerns that we have on Clause 28 of the Justice Bill, setting out proposed reform of taxation. But to start on a point of optimism, there are some aspects of the Justice Bill which we view as positive, so I want to address those. And firstly, perhaps part 2 of the Justice Bill, it deals with the custody and bail of children, and the relevant provisions here ensure a presumption of bail for children. There is an active presumption against children being detained in custody and refused bail due to a lack of suitable accommodation. And as you know, Clause 14 also adds that the court must openly state its reason for remanding a child in custody for more than 3 months. And the inclusion of these measures, we feel, is progressive, and the Bar is supportive of them. It's a common sense and evidence-led policy position that children should only be placed in custody as a measure of last resort. Secondly then, I'd like to highlight part 4 of the bill, and specifically Clause 25, which closes a gap. At present, again, as you know, a judge can enter a no bill for a manslaughter or murder charge, but cannot do so for the related charge. So it's to be welcomed. We feel that the gap can now be closed by Clause 25. Moving across then to Clause 28 of the Justice Bill on taxation. The first question is perhaps, what is taxation? Perhaps it is a misunderstood process, but quite simply, taxation is the assessment of legal costs under a long-established process whereby a bill for legal services is reviewed by the taxing master to determine whether or not charges are reasonable for a service provided. Fees can be marked up and fees can be marked down. Most importantly, though, the taxing master is an independent judicial office holder performing a judicial function. And at this point, I'd like to pass across to the Chair, Donal Lunny, KC, who will take you through some of the particular concerns that the Bar has about that clause in particular.
Thank you, Denise. I'd like to echo Denise's thanks to the committee for having us here to give evidence on this important bill and on the important topic of taxation. Clause 28 is the relevant clause, and we see it as proposing radical changes to the assessment of taxation of legal costs in this jurisdiction, and it does that by inserting a new provision, section 59A, into the Judicature Northern Ireland Act of 1978. The very clear aim of clause 28 is to remove entirely any role for the court, and the court is usually the taxing master, in determining the fees to be paid by the Legal Services Agency to the lawyers of a legally aided person, where in any civil or criminal proceedings before the High Court or the Court of Appeal, the LSA, rather than the opposing party, is responsible for paying the legally assisted person's costs. This most often arises, as you probably know, where the legally assisted person loses their case. The Bar of Northern Ireland has some serious concerns around this proposed provision. It's a radical change, and I'll explain those concerns now in summary. First, clause 28 we see as a direct attack on the independence of the taxing master as an independent judicial office holder performing a judicial function. As you're aware, I'm sure, it's a settled and fundamentally important principle that the judiciary should operate without interference that's inappropriate or unwarranted. The policy intention or imperative around the interference that clause 28 represents is neither, in our view, clear or convincing. The taxing master is already legally bound to protect the legal aid fund. That's a duty. And there is absolutely no evidence that we're aware of any failure to fulfil that statutory obligation, nor even any evidence of the department having alleged that. It's unclear to us what the department perceives to be the disadvantages of having a demonstrably independent system. It hasn't articulated the comparative advantages of any alternative approach. And the Bar has to question whether the department simply doesn't like the outcome of some taxation decisions in respect of legally aided cases, and is therefore seeking to remove publicly funded cases from taxation altogether. Now, the precedent that would set, where a government body removes a class of case from an independent judicial process because it doesn't like the results of that process, should be of grave concern, not only to this committee but to all citizens, we submit. Secondly, the stated policy aim of clause 28, which is achieving certainty and predictability around the legal aid budget, is to a significant degree unachievable. Legal aid is demand-led. We say that the department must adopt a needs-based approach to legal aid and allocate to it an appropriate budget which invests to deliver a quality, high-value service to all citizens in receipt of publicly funded legal services. The committee also should be advised of the pre-existing checks and balances that exist through the judicial function of the taxing master. The department, they have rationalised the policy change upon a Northern Ireland Audit Office report that was published some 14 years ago, and upon a Public Accounts Committee report that was published 9 years ago. One concern raised by the Public Accounts Committee in their 2016 report was an, and I quote, unacceptable level of claims submitted by the legal profession that are disproportionate or not reasonably incurred, end quote. In arguing this, they quoted figures that were provided by the department for the years 2012-13 until 2016, and those figures showed that nearly 90% of bills were reduced to some extent after taxation, and overall that represented a reduction of some £9 million in claims of £69 million, so that's about 13% of a reduction. With all due respect to the PAC, this criticism, we say, was both unfair and, more importantly, missed the really important point. The fact that fees are sometimes reduced or disallowed on taxation is positive proof of the value of the system. In addition, we say it's important to recognise that there are safeguards and sanctions in place to ensure that practitioners do not mark an excessive fee. Speaking for the bar, clause 30.2 of our Code of Conduct provides as follows, and I quote, "It's improper for a barrister to mark an excessive fee. A substantial reduction on taxation of the fee marked may be deemed to be prima facie evidence of professional misconduct." End quote. Secondly, as we see it, you, as members of the Assembly, are being asked to vote blind on clause 28. It remains entirely unclear what the alternative methods of assessment will be, what the time frame for them is, and how the future systems will recognise the time and skill invested by solicitors and barristers. We, of course, appreciate that the Department does intend to put some other system in place. However, the sequence of legislative steps here is of potentially great importance. Rather than have you as MLAs decide whether or not to remove taxation in a context where you're able to assess the adequacy of the proposed alternative, you're being asked to take the first step on the basis that the Department won't commence the relevant provision, and it is them who will decide when to commence it, not the Assembly. In effect, as we see it, you're being asked to give the Department, a department that says it's concerned to be prudent, the legislative equivalent of a blank cheque. As for potential alternatives to taxation, we're concerned that the Department may introduce statutory scale fees, which are not viable for a number of reasons, but amongst those is the very obvious one, and that's the Department's repeated inability to review scale fees in the limited areas where they have been introduced in our jurisdiction. And by way of examples of that, family care centre fees are dictated by the Civil Legal Services Remuneration Order, Northern Ireland 2015, and the Department has not fulfilled its statutory obligation to review those fees at all since 2015. As for Crown Court fees, the Department's failure to review is, I'm afraid, very well known in light of the Criminal Bar Association's current withdrawal of services. Thirdly, and finally in this regard, one very important indirect consequence of the removal of taxation of fees in legally aided High Court and Court of Appeal cases is that it will undoubtedly create a two-tier system of access to justice. Now, it's unclear whether the Department has simply failed to consider this very foreseeable consequence of their actions, or whether they are simply carrying on regardless. Fundamentally, the Department wants to remove taxation from these entire swathes of litigation so as to reduce the legal fees which they, through the LSA, have to pay. So whatever their alternative system is, it will almost certainly result in lower fees for lawyers who act in legally aided cases. One foreseeable effect of this will be to discourage lawyers from acting in legally aided cases when they have the option instead to act in non-legally aided cases, where taxation of costs will remain available. And this obviously risks leading to a system where, unlike at present, the best lawyers will act only in non-legally aided cases. That seems obvious to us. We'd ask you also to note that the Justice Bill doesn't purport to deny access to taxation to all litigants, but only to those litigants who meet the financial conditions for access to legal aid, and only where the legal aid fund is paying. And an example of the disparity there is if you take a prisoner injured in HMP Maghaberry who obtains legal aid to sue the Department of Justice following an injury sustained while working in the prison kitchen, he will have no access to taxation of costs if he ultimately fails in his claim, whereas he will have access to taxation of costs if he wins. A non-legally aided Department of Justice employee working in the same kitchen, in the same prison, will have access to taxation of his costs if he wins or loses his claim against DOJ. Finally, in this regard, I'd like to contextualise our evidence in some of the narrative that we are constantly exposed to about legal aid. Northern Ireland's system of legal aid is often described as, and I quote, generous. Furthermore, on occasions, unfortunately, the citizens in receipt of legal aid are described in the media and by some others as if they are somehow undeserving. As you well know, legal aid is one part of our cherished welfare state. It is a demand-led and a means-tested public service. Those who meet the eligibility criteria to avail of it have the statutory right to its assistance. Across this jurisdiction in 2023-2024, almost 64,000 citizens were granted legal support and assistance. And we know you won't lose sight of the fact that these individuals are your constituents and our fellow citizens. There is a direct correlation between demand for legal aid provision and socio-economic challenge. We can profile greater demand for legal aid in council areas experiencing long-standing socio-economic difficulties. And unsurprisingly, that causal relationship results in public expenditure per capita being higher in Northern Ireland than the UK average, and that applies in several other areas such as health and education. It's certainly not confined to legal aid. So I'd like to conclude our evidence at this point. Denise as Vice Chair, David as Chief Executive and myself are very happy to take any questions you can, and hopefully we'll be able to answer them as best we can.
Thank you very much, Joel. Thank you very much, Denise. Usually in our closed session, I organise our questioning, and I negated to do it this time, so I'm going to do it now. If you'll just bear with us a second, but I think it means we can direct things rather than jumping about throughout the bill. Could I ask members to indicate if they've got questions on the children's bail issue? I do. Anybody got anything on the no bill issue? I'm presuming the bulk of questions are going to be around taxation. Who's got questions around taxation? Could you indicate now? Nobody? Deirdre? I've got a couple around those two. Does anybody have any further questions on anything else in the bill that they wish to ask members of the bar? Doug?
Sure. I have a general question I would like to ask if that's possible, please.
Yes, Justin?
Yes, likewise, and in relation to code of conduct.
Of conduct.
I might indicate to come in, Chair, if that's okay.
Right, yes, we'll afford people the opportunity to come in, but it's just so that we've got some structure with regard to how we proceed. Can I maybe ask for your opinion on something without being charged for it? We've been having some discussions around the children's bail issue. There are clauses in there and where there's reference to a child being denied bail on the basis of public disorder. And we haven't been clear whether or not that is because the child might engage in public disorder or whether there's a threat of public disorder as a result of the child being in receipt of bail. And I suppose I'd be interested in your interpretation, but also around the issue of where it is interpreted as being that public disorder would result from the child being granted bail. Could I ask your view on, it seems to me that you have a right to bail or you do not, and it should not be determined by a potential mob rule situation where people threaten public disorder as a result of that right being granted. Could I ask your opinion on that?
I suppose the important thing about bail, almost regardless of the Justice Bill, is that it's determined usually by a judge, usually by a very experienced judge, after hearing submissions on each side from legal professionals, quite often solicitors, sometimes barristers. risk of the person seeking bail reoffending is always something that has to be taken into account. It's quite a common, as you probably know, reason for bail being refused. A less common but not unknown feature in adult bail applications is where someone is refused bail because of a danger to them, a risk to them. As to what that risk could be caused by, that could be a myriad of different things, and sometimes it will be because of the nature of the crime they're rightly or wrongly accused of. Sometimes those sorts of issues, they don't arise often, but they can be catered for in the conditions that are set.
Yes.
But it is a very difficult task for judges in some cases, particularly cases of the type you've mentioned. It's not immediately clear to me. It is something we could take away and consider and come back to you in a paper.
I think we need to get some interpretation from the department as to how it envisages this. But I mean, certainly, I would be concerned that if somebody has a right to bail, it shouldn't be a mob within society who determines whether or not who can influence that. And I felt that might be a rights issue. But
I think if I can come in, I think you're right. On an objective reading of the draft clause, it could potentially encompass both those things that you have suggested, Chair. So the risk that the child themselves would cause a serious threat to public order, or the risk that there may be some other serious threat not emanating from the child themselves but relating to the fact that they are receiving bail. So I agree with you that there is a potential interpretive issue, and it may be that it's something that needs to be taken to be clarified with the department, but I agree with you that as drafted it is perhaps capable of meaning both those things.
And if it were to be interpreted as there would be a serious risk to, or there would be any risk to public order as a result of the child being released,
an impact on its human rights.
Is that just?
It could be very broad, and I mean, ultimately, as the Chair said, these are all matters that judges have to determine, and experienced judges are well aware of the types of issue that may arise. So it is a matter for a judge to consider all the circumstances of a particular case.
Okay, that's fair enough. Thank you very much, Denise. Connie, you wanted to come in on this point?
Yes, it was under the section of, just under your section of the custody and bail of children. It wasn't the exact same point, Chair, so I'm happy to hang back to the very end.
Is
that okay? Yeah.
No, we're dealing with this section now. So
okay, apologies. I know I didn't come in when we were coordinating there. I was just really interested, and I appreciated that you'd included about the minimum age of criminal responsibility, raising from 10 to 14, and that's something that I would really support as well. And it's something that we, as a committee, heard from presenters last week. And I think what I'm really interested in is we heard from another organisation who had said they would like the age raised to 16, and you've said from 10 to 14, and I think most people are agreed 10 is far too young, and I really appreciate maybe just a wee bit more about your rationale for settling on 14.
We looked obviously at the draft bill. We're aware of some of the arguments on both sides. We're of the view it needed to come up for a number of reasons. Obviously there's no such thing really as an average 10-year-old or an average 14-year-old or an average 16-year-old, and 14 appears to us to be reasonable. That's not to say there aren't arguments for it both being a little bit higher or being a bit lower, but the department, we believe, pitched it at a reasonable point.
And we, I think, provided a response to the department's consultation on that. So if it would be helpful, I'm sure we can provide that to you if that would help explain the rationale.
Committee are content with that, yeah. I think It's something that's come up, 2 weeks in a row now looking at this bill, so I think it might be something that comes up a bit more as something that wasn't included, and I think it would be interesting to know and to have your response. I'd really appreciate some more information on that.
I think the main aim we were driving at was alignment with the principles of the UN Convention, really. But our paper that dealt with that, we can certainly provide it as assistance.
Yeah, thank you.
And if it doesn't answer all of the questions that you might have, or as is often the case, if it maybe when you read it gives rise to some other questions, we've no problem trying to answer those, if that's...
No, that's really appreciated. Thank you.
Thank you.
Thanks,
Tony. I mean, you alluded to why it wasn't included in the bill. I suspect the reason it's not included in the bill is because there wasn't political agreement around the executive table on it. Because I think that a number of us who are of a certain age will recall the Jamie Bulger case, which was very traumatic, I think, for our nation as a whole to read and watch and see what had gone on there. And I suppose, and that's why there are arguments either way, I suppose, because people are also conscious of what can happen even from very young children. But I suppose that's something that we'll try and figure out as we work our way through this. So nobody has anything on no bill. I'm going to take general issues before we head into taxation. Doug, you had questions on general points?
Oh goodness, yeah. Sorry. I mean, it is a general point, and it's a little bit off topic, I think, possibly. But I can hope you can see how I'm correlating the two. And it's in regards to the legal action that's taking place at this moment in time. Now, I'm not getting into the argument of whether you should, whether you shouldn't, or anything in regards to that. But the delivery, because of there's no delivery of legal aid cases now. I think there's about 17 cases of some very vulnerable people, some who are suicidal, some who are at the end of life, who are now not getting through the course as they should do. So the question is this: do you think, like we had with nurses, for example, when nurses went off on strike, they had a minimum standard that they were still going to provide? Do you think the legal profession should have that minimum standard, and that minimum standard should be contained within this bill?
I suppose there are a number of aspects to your question there. Whether a minimum standard of delivery of work should be imposed on any group of workers, profession or not, is a very difficult question, and it's one that's going to elicit a lot of very strong views, whether you're a nurse or a barrister or a fireman or someone working in a data centre or a factory. We don't have a formal position on it. It's not something we've been asked to consider before. So I don't think it ought to be in this justice bill, and it isn't. As a matter of principle, I suppose, looking at the actual facts, our members have withdrawn from one portion of the criminal justice sector, so Crown courts. That's not where the majority of cases obviously are. It's where the most serious cases are, but not the majority. So it's one sector, or one part of one sector, criminal justice, for a defined period of time. It was an absolute last resort. It wasn't done, as you know, you've heard me say this before, it wasn't done lightly. It was done as an absolute last resort by a group of people who are very, very well aware of the seriousness of the cases, the effects those cases have on victims, and the effect those cases have on accused persons and jurors and the legal professionals who appear in them through vicarious trauma of doing case after case of that type. Our hope is that we can find a resolution to the dispute. That's not something that's within my power or the Bar of Northern Ireland's power. It requires a number of parties to sit down and engage meaningfully if that's to happen. But as I say, this was avoidable. It was a last resort, and it's time limited as things stand. The other...
Paul, if I could just come back and firstly just reiterate that I guess I'm not being critical one way or the other in regards to this, and please don't think that I am. But I'm looking at this as a public service and a public service provider, and when I look at what happens elsewhere, and they do provide a minimum standard when they go out on justified strike. And look, I'm not saying it's not justified. It clearly has merit. That's kind of not the case that I'm making. The case I'm making is that there can be or should be a minimum standard. So if we have somebody, for example, who's going through a case who is close to end of life, and I'm hearing that we have that case, that minimum standard is able to ensure that particular case is able to go through the courts. I know it's not in the bill. I know you're saying it shouldn't be in the bill. Maybe that's wrong of me then to ask, but I'm just trying to get a sense from you if you think that is something there should be.
I think that would have to be a much broader conversation, because the action that has been taken to date has taken place across 2 months, January and February. Now, the first week in January and next week are weeks when the courts don't generally sit in those types of case. So it's not even 2 months of delay that's been caused. Our system in the Crown Court is beset with much greater structural delay than that. That is something we, and I expect you, want to see addressed. We want to see cases progress much more quickly, fairly, through the system. So, you ask the question, should there be a minimum level of service that solicitors or barristers have to provide? I'm absolutely more than happy that our bar have that conversation, provided it's in a context of should there be a minimum level of service that the Department of Justice have to provide. And I'm perfectly happy, Doug, it wouldn't be Mr. Beattie, wouldn't be the appropriate forum obviously here to talk about the facts of any individual case, but offline I'm absolutely happy to talk about the facts of any individual case if there is a concern.
No, listen, thank you, and Doug's always fine, by the way. Chair, thank you.
Thanks, Doug. I think that some of these issues we can certainly explore when the bar returns to talk about the Access to Justice Reform Programme. I think we can explore some of these in a bit more depth. And actually, I was just saying to the clerk, it also would be very helpful. I mean, Donal, you've raised the issue around delays in the system, which seem to have plagued the system. I mean, a lot of it is pinned on COVID, but I think that there were issues long before that. And it would be very helpful to see and to hear from you what your views are as to what might be some of the solutions around those issues too. But we can return to that, and no doubt we'll be seeing you very soon on some of those issues, so that's fine. Justin, you had something general too?
Yes, Chair, and thank you, Donal, thank you, Denise, thank you, David, for your evidence. On the same issue as Doug has raised, has the bar taken any measures to mitigate against the most severe risk as a consequence of strike action?
Well, it's done a number of things. It obviously, as I've said, this was a last resort. It took other steps first. Many of our criminal bar members wanted to take this type of action in the summer of 2023. They restrained themselves, even though they had very good cause at that point to do it, and they engaged bona fide in the review under Judge Burgess. They took part in that. People gave up huge amounts of time, provided a lot of evidence, as did our solicitor colleagues. A huge amount of very collaborative work was done there under the stewardship of an independent expert, a man with huge experience of the Crown Court as a judge. He produced his work in August, and as you know, you've heard me say before, the department then didn't publish it to anybody until December, including you as the Justice Committee. At that point, because of the trajectory or the direction of travel that the department set, the bar felt they had no alternative but to take action. There were a number of different types of action discussed. many of the options that were discussed were more severe than the option they voted for, which was to withdraw for January from Crown Court cases. We hoped that would be enough, but it wasn't. It didn't prompt meaningful engagement within January. So they took further action, but they time limited that as well. And again, more serious action was discussed, and they chose not to do that so that they weren't affecting everybody and that it was time limited. So they have been restrained in what they've done. They have thought about the victims. But I think it's really important to make this point. There may be short-term disruption, and we're acutely aware that that causes some delay to some trials, and that obviously affects some victims and some accused persons and some witnesses. But the system being structurally underfunded and in a crisis is a much bigger problem. That's going to cause long-term harm to victims. If people aren't paid properly to represent defendants in criminal trials, what you will have are verdicts that are unfair, miscarriages of justice, people wrongly convicted, and that leads to appeals, to acquittals sometimes of people who are guilty and ought to be convicted. It leads to retrials, and none of that is in the interest of any victim. So what they have done, yes, it causes short-term difficulty, but the motive behind it is to remove a much bigger, much more damaging long-term problem.
I kind of, look, I'm acutely conscious that we are going to spend time on this, and time on the programme and the strike and progress and where you are and your views on it. So I'm eager, members, that we don't get into the minutiae of this, because this is about this particular evidence session is about the bill. Now, inevitably, issues will arise, but I don't want us to get into the machinations of all of this whenever we're going to have a specific session on it. And I think we should, allow the bar to come and make their opening statements on that issue, and then we can ask questions specific to the issues around that programme and the strike action. So, Justin, could I ask you to bear that in mind if you intend to follow up? That there's going to be a dedicated session on the access to justice issues.
Sure, I appreciate the bar are in a quandary, and there are multiple issues with the department and the system that puts them in such a difficult place. But I do also recognise that there are people who are left in very vulnerable places because of this. And I note that Donna's point around this could have been avoided, and I would like his perspective on how it could be avoided.
How it could have been avoided? It could have been avoided with meaningful engagement by the department with us and our solicitor colleagues at a much earlier stage. That's the short answer. If we can, and I can expand upon that in a separate evidence session when we come to it.
That's fine, Chair. Thank you. I have another question in relation to code of conduct, but I'll take that later if that's okay.
No, you go ahead on your code of conduct one, Justin, because we're about to move into taxation.
Okay. In terms of the code of conduct for the bar, how many such cases of professional misconduct is the bar aware of in relation to fees marked above the level that they should have been marked?
I don't have exact figures for you. We can produce them. We have a system of robust self-regulation, but the Professional Conduct Committee of the Bar is entirely separate, hermetically sealed from the Bar Council. So I can't give you a figure like that off the top of my head, but we can obtain them. But I can tell you happily, referrals for cases like that, for complaints like that, are small in number, but they do occur. And when they occur, if there's a prima facie case of misconduct under the provision that I've quoted, clause 30.2, then they are prosecuted before a disciplinary panel. And there are at least a few of those cases alive and ongoing in our professional conduct system at the minute.
Okay, excellent, Donald. In terms of that robust self-regulation in relation to your code of ethics around do not break the law and do not bring disrepute onto the bar, how would a member of the public who has concerns about the actions and behaviours of a particular KSC bring those concerns to the bar or otherwise in relation to them using their knowledge of the law to shield and protect themselves from potential criminal behaviour?
I think the first very important point, Justin, to note is that our code of conduct doesn't say don't break the law. It's much more rigorous than that. Obviously, the code of conduct that applies to all of us as citizens is do not break the law. If a barrister or a solicitor breaks the law, there will be code of conduct and other consequences for them. But our code of conduct imposes upon us obligations that are much more rigorous than the obligations in the general criminal laws.
You're officers of the court, really, aren't you? So.
We have duties to the court. We have duties as independent legal professionals. Our code of conduct, which I'm happy for you to see a copy of, it's publicly available. It's front and centre on our website. You will almost certainly have a copy of it in your library here in the Assembly. It evolves all the time. So I can give you an example. If you have a constituent who wants to complain about a barrister, our website, Bar of Northern Ireland, it's the first thing that comes up if you search for us. It's very easily found on the website. There is a form they can fill in. There are staff who deal with this, who deal with complaints from any lay person. You don't need a lawyer to make the complaint for you. Last year or the year before, proactively and ahead of many of our analogous professions, we altered the standard of proof in respect of professional misconduct from the criminal standard to the civil standard. So that makes it easier for someone to be convicted of professional misconduct. So that's one of the reasons why I use the adjective robust when I describe it to you. But again, we can send you a copy of the code and the relevant web page if that would assist.
Link probably is fine. Thank you very much, Donald. Okay, Justin, yes.
Thank you, Chair. Thank you,
Okay,
folks.
we're going to move fully into taxation. I appreciate you've touched on it there, Justin, and that's good because you've asked one of the questions that I was going to ask, so I'll strike that one off my list. Deirdre, I'm going to come to you now.
Yeah, no, thanks very much for coming in. And obviously, the Taxation Master is something that we are particularly looking at. And I know the Department have said it's what they've contained within the bill is part of their responsibility for managing public money. So it's just interesting in the point you made that that's also a duty on the Taxation Master. And we have obviously asked as a committee for the Taxation Master to come in and present to the committee as well, because obviously it is a technical piece of work that we're not all across, and it would be useful for us just to hear from their perspective in terms of the checks and balances, that they do in terms of managing public money. But Donald, you outlined just in your comments, and I know in the papers, in terms of the potential of a two-tier system, and I know you give one example, but it's just to see if you could expand on that. And the other issue in your opening around, because on the one hand you could look that this is a grab just for the department then, to take control of it, and it's that issue of independence and the potential of maybe some of the decisions or the outcomes they don't like. Could you expand on that as well, just to try and give us a flavour of what potentially you mean?
Well, as you know, lawyers, we have certain skills. We can be very good at looking at something and saying, well, here are the short-term consequences and ramifications of that, and we can conceive of longer-term or indirect ramifications. And we look to see what precedent something might create. But you have a situation here where if you don't personalise it, it is a government department that is obliged to submit itself to an independent judicial process for one facet of its responsibilities and duties. It clearly doesn't like the outcome of that process. It doesn't like what that judicial figure is doing. So it is saying, let's take that part of our duties and responsibilities away from that judicial process and do it in-house. Now, if you think of it in those very bland terms, put some other government department or arm's length body in there in place of the Department of Justice, put the police in, put HM Revenue and Customs put somebody else in. It's a disturbing potential precedent, and a precedent that, if you allow it here, might be relied upon in some other context in the future. So we know one reflexive reaction to this reform is to look at it and say, lawyers' fees, who cares? It doesn't affect me. We say, yes, it does. It does affect you because it's potentially going to create a two-tier system, which I can expand on separately, but you should be concerned as a citizen or an MLA about the potential ramifications, the potential precedent this could set for other state bodies who don't like the outcomes of independent judicial processes that they're obliged to put their work in front of. The two-tier system, we have said before, both in writing and in venues like this, that a great benefit of our legal aid system, our publicly funded legal aid system, is it helps prevent there being a two-tier legal system. It helps prevent us being like the legal system in the United States of America. And it's very important to note that if lawyers always only voted with their pocket, then you would vote for a system like the one in the United States of America. A two-tier system makes most lawyers richer. We don't advocate for that because we know that our system is better. It's better for citizens. And taxation is an important part of that. If legally aided people's fees are not subject to taxation but fixed by some scale that will undoubtedly in many cases be lower than what taxation would produce, that will deter some lawyers from doing legally aided work. It will also, and this is where it gets maybe more arcane and complicated, there is a principle surrounding costs and your entitlement to recover your costs from the losing side in the case called the indemnity principle. If I am legally aided, even if I win my case, if the system as the department wanted to become is one where my fees, if I lost, wouldn't go to taxation, they would be paid on a scale that's lower, then if I win, you can expect that when I put my bill in to the taxing master then, because I'm not relying on legal aid, it's the losing party is paying. So in my example, the Department of Justice, the prisoner wins his case, the department will say, well, you shouldn't get any more on taxation than you would have taken if you had lost under the scale. So indirectly it will affect what you can recover when you win. And that will create a two-tier system. It will deter lawyers from doing legally aided cases. And, not wanting, given that we're here to talk about the Justice Bill rather than the withdrawal of services, not wanting to go back to the withdrawal of services, but we're already seeing it in relation to the Crown Court. Younger people coming to the bar who are incredibly bright, who are incredibly hardworking, many of them have made huge sacrifices, incurred huge debt to get to where they are choosing not to become criminal lawyers. They're doing other types of work because those other types of work pay fairly. So the two-tier system, the start of it is here. This will just speed it up further.
Oh, that's great, thank you. And I suppose just I know we're not regressing back into the legal aid stuff, but obviously it is time sensitive because there's ongoing action, and I think just your statement kind of set out the frustrations around that lack of engagement, and that's something we've been asking questions of the department and indeed the minister as well this week as well. So I know there's been meetings, there was meetings on Tuesday, so I would be keen at some point whether we get that meeting next week. Yes. With yourselves coming back up to look at the wider issue, but just in terms of the immediate strike action and a way of trying to resolve that.
Yes.
What the outcome of that meeting was, and is there kind of positive soundings in terms of trying to move this situation forward in the short term, but also certainly looking at the medium to longer term changes.
And I can indicate, in fairness to the department, there has been some engagement this week with both ourselves and our colleagues in the solicitors profession on Tuesday of this week. So that engagement has started finally.
That's interesting. Finally, there is interesting. Ciara, you wanted in on this?
Yeah, and just want to note, obviously, maybe just for the record, that I am a member of the Access to Justice All Party Group, where obviously the bar would be a secretariat of. clause 28, obviously, and listening to yourself, particularly, Donal mentioned the words serious. You feel that clause 59A in particular is a radical change, and the independence of the judiciary is potentially under attack in some respect. Could you maybe expand on that a bit? And likewise, you mentioned in your report the example of England and Wales and what they attempted to do back in 2021. I would really love to hear, maybe, given that we're 4 years on, what has been the impact of that, and just really how is the sector feeling about this? Is there any positives in moving from the taxing master to the department accounting officer in relation to setting the fees? Is there any advantages as well? So there's maybe 3 questions there.
Taking the last one first, the department in their explanatory and financial memorandum surrounding the bill refer to a principle known only to the department, and that is, if the department are paying, the department decide what you get paid. That's not a principle we're aware of. The principle that everybody's aware of is that if you can't agree the cost figure that's payable, it goes to taxation. And taxation it's an independent judicial officer. It's what we would call the gold standard. So if you can't agree what the costs are, it goes to the taxing master, and the taxing master decides, was it incurred, was it reasonable to incur it, and is the amount reasonable? And as you heard me say in that opening, the proof positive that it actually works is the point that the PAC thought they could use to beat the professions with and taxation with, and that is that sometimes 13%, or by 13% across the board, across a 4-year period, fees were reduced. And we would say that's absolute proof that this gold standard system works. It makes sure that people aren't overpaid. And I don't know whether Janice has anything. I can't remember your third question.
You asked for a general impression, and it follows on from what Donal just said, and what he said in his evidence session. There is no evidence that the taxing master isn't doing their job properly. And we've given you some statistics about that. And in that particular context, it's very hard to see then the justification and rationale for doing this. And particularly now, because we can't see what the department has to fear from an independent judicial officer doing their job properly. As we said, some fees go up and some fees go down on taxation, and that is appropriate. That's as it should be. So there's a general, I suppose, a lack of justification, we feel, for taking this step, and in particular taking it now without having outlined what there is to replace it.
And just in relation, you had mentioned about England and Wales and back in 2021.
So they didn't proceed with those reforms because they met with resistance. So they still have the system of taxation as we know it. They call them a senior cost judge, and they have various other cost judges, but it's taxation as we know it, though they have an alternative system where you can, for lower value things, submit them without taxation, but everybody still has the option to tax their costs. And we maybe can submit to you afterwards if you want that we've a short summary of what the position is in each of the analogous jurisdictions, so Scotland, England, Wales, Republic of Ireland and here. I do think it's also very important, because I completely appreciate not only are the public no doubt tired of hearing lawyers talking about fees, but there's sometimes a perception, unfairly, that both our profession and the solicitor's profession are resistant to any change. The reality is, of course, we're not. Can the system be made better? Of course it can. They all can. There are some aspects of our system that work really well, and where there are some problems. So if there's a problem, and the chair has touched on this before, about predictability of what fees will be, and that helps with budgeting. There are ways that we're open to exploring of improving that, but none of that requires a removal of taxation. This is absolute, to the extent that there are problems with things like predictability. This is a massive sledgehammer to crack a small nut. In what legal services call money damages claims, so what are generally personal injury claims, we have a system where we have a thing called the Comerton scale.
Yeah.
And the Comerton scale, it's been on the go. It's a well-respected, recognised by the High Court, approved of by the parties that pay, who are largely big insurers. And it is a scale that is a scale in inverted commas. So it's derived by the bar in consultation with solicitors and the taxing master. It's updated with inflation every couple of years. And it's a guide to what you should mark in most cases. And most people use it in most cases. And that introduces a huge degree of predictability. You still have taxation for the exceptional case, because obviously sometimes you'll have a case that's exceptionally complex or exceptionally important as a precedent, but in money terms it's not worth a huge amount. Those cases can all proceed to taxation in the normal way, but for most cases, most people take the swings and roundabouts approach of the guide that is the Comerton scale, and it's been in place for a lot longer than I've been at the bar. Now it exists in the money damages field, it doesn't exist in other fields, but there's an issue that could be explored about whether we can do more to introduce greater predictability into the system. So it would be wrong, and I would hate you to get the impression that we're against, it's lawyers against change. It's absolutely not. We're keen to explore every way in which we can make the system better without damaging it.
And would you be, just one final one, just on the back of that, and we did have departmental officials in here a few months back in relation to, and this is there was ongoing liaison and work with the taxing master and exploring. Have you any update on what considerations or models that department officials would look to?
No, and I suppose we can only look to past behaviour as a possible guide for future behaviour, and past behaviour has been in the narrow areas where they have imposed scales instead of taxation, Family Care Centre and the Crown Court, they have never lived up to their responsibility to review those figures, which is why you've heard me say before that on the Crown Court scale for solicitors and counsel, fees were set in 2005 and they've never been increased. So if the department comes saying, trust us, we'll set a scale and we'll review it, you'll forgive us for not placing any faith in that type of arrangement. And it doesn't have the flexibility to deal with the exceptional cases, because as you probably know, not all cases are the same, and some cases that may not involve the most serious criminal offence or the most serious family remedy in a family case or the largest amount of damages can be very time consuming, very legally complex, and can be of huge value in terms of setting precedent. So but we don't have we don't know what their alternative is, nor more importantly do you. You're being asked to write them a blank check, and once this provision is in law, if you look to the end of the bill, it's the department decide when to commence it, not the Assembly. So it surely makes sense that it's at least an informed debate where you're presented with the alternative or alternatives, and you can make an informed decision about whether you're going to enact Clause 28 or not.
Thank you.
Connie?
Thank you, Chair. Apologies, Chair. Ciara jogged my memory that I'm also a member of the APG.
I think nearly all of us are, to be honest. So
if that is a declarable interest, I will declare it now from the outset. And thank you for a lot of this. I have to say I'm quite new to this committee, and a lot of this system was a learning curve for me, especially learning about the taxation master. I think we do need to remember that this is a social security. It's about enabling access to justice for those who need it, and the taxation master was something that definitely it took me a while to get my head around, and I appreciate the information you've brought today. And I just wanted to kind of talk about some of the figures you'd mentioned. One of them was 90%, where the taxation master had reduced bills by 90%, and I think that's from a PAC report that was published. And but do you recognise and accept that figure?
Yes, it's just very important that we say it in precisely the right way. He hasn't reduced bills by 90%. Bills have been reduced in 90% of
90% of
the cases that they
apologies,
considered in that period.
And overall, they've been reduced by
13%.
So that's about an average of 13%. And from, am I right, just from your perspective then, that is evidence for you that the taxation master is doing their job robustly because they are changing the bills in 90% of cases?
Absolutely. It shows that it's not a rubber stamping process where lawyers put in their bills and someone just goes, yep, that's fine, there's no scrutiny. But to be honest, rather than hearing that from a vested interest, that might be something you would be better. The taxing master can give you an objective explanation of how the process works. We consider it, as I've said, to be a gold standard. You have an independent judge. If it's a legal aid fee and it's legal aid taxation, the independent judge is duty bound to protect the legal aid fund, precisely as you say, because it's part of the welfare state. It's all of our money. So we see that as the gold standard. But we also, it applies, taxation is available to everybody else. So if the department take a case against somebody and they win, their lawyers can have their fees taxed. If someone wins a case against the Department of Justice, if the Department of Justice make a procurement mistake when they're buying something for the prison service that might run to millions and millions of pounds, and they're sued in the commercial court and they lose, and they don't like the fees that the winner's lawyers are marking, they can have those taxed. So they'll still have the benefit, the department will, when it's their money and their cases, but it'll be denied to the people who are representing legally aided applicants and plaintiffs and defendants.
If I could add a small, perhaps additional piece of context over the history of taxation, you'll be familiar, the committee is certainly familiar with issues about payment delays and fees. So it would not have been unusual for somebody, rather than appealing a decision, which they could do upon taxation, to just accept the taxation decision. Why would they do that? Because they've already waited so long to get their fee determined, and the work is of such vintage that they need to get the cash flow. I'm not saying that reduces, I couldn't say what extent that featured in the statistics that the Public Accounts Committee was looking at, but it is a common feature of the system that people are sometimes notified about a reduction on taxation. They have the option to appeal, but they forgo it, even though they may have a very strong case, and they forgo it because they need the cash.
Thank you. I think it is something the committee had said would maybe look into a bit more, because the taxing master role. And if I could just have one quick follow-up, and I do mean this genuinely, does it cause you concern that 90% of bills are reduced? That does seem like quite a high figure to me, especially when you did also cite that your code of conduct includes excessive charging. Do you have any concerns that 90% are being reduced?
I don't, partly for the reason that David has mentioned, but there are a number of reasons why I don't have any serious concerns. One is that there's a very well recognised phenomenon that David has mentioned, where you put in your bill, you wait 4 months to find out that it's been taxed and that it's been reduced by 7% or 8%. If you seek to have that reviewed, which is the first step, that takes time. The taxing master is one person, very busy, and also has a separate role as the judge responsible for the enforcement of judgments, as well as his taxing role, or his fee assessment role. So what you're doing by challenging a 7% or an 8% or a 9% reduction is you're putting the money further away in time from you receiving it, and you don't get interest or anything on it. That fee will be the same amount whenever you eventually get it. So a lot of our members are very pragmatic about that. They'll say, I don't believe it was right for my fee to be reduced by 10%, 14%, 8%. but I can live with it. I'm not going to challenge that. I'm not going to take the extra time, take the couple of hours to go round to the taxing master to a hearing to justify why that particular hearing needed a skeleton argument, or why that hearing ran into a second day, or whatever it might be. The other reason that I'm not concerned is because if I were seeing many cases going to disciplinary hearings where people were having their fees reduced to the extent that they were being reported to the PCC and prosecuted, then I would be concerned. But I'm not seeing that. And very much I see that as the taxing master doing his or her job properly. Fees are being scrutinised, and if something can't be 100% justified, or there's a doubt, the taxing master is erring on the side of caution and saying, I'm not going to allow that fee. And there might be one or two individual cases that might go to disciplinary hearings where people have been reduced by a very significant amount. But as you can see, across that 70 odd million, it's a 13%. Across a 4 or 5 year period, it's a 13% reduction on average.
Thank you. I appreciate that. And any further questions, I think, probably do stray into the access to justice piece widely, which we're obviously following up with next week. So thank you.
Yeah, well, maybe next week. My turn, guys. Thank you for everything that you've said so far. You'll appreciate, I mean, this is a tricky area for us, and from the outset I want to say two things. One is that for my part and for my party's position, we are very conscious that this is public money, and around public money there must be accountability and transparency. That said, we also believe it is right that people should receive fair pay in a timely fashion for work carried out. So the issue for us is finding the best way for that to happen in the system. I'm not sure. I'll work through some questions that I have. You've provided us with a paper on brief fees, which I think is really important. I think the brief fees issue both falls into the bill, but also falls into the access to justice reform issue. And I'm really not clear whether to ask my questions now or whenever you return. So we'll see how we go. But look, first of all, you've referenced the Northern Ireland Audit Office, Controller and Auditor General, and the PAC and their various reports. In the course of that, of those reports, did they speak with you? Did they consult with you at the time?
For my time, I'm afraid.
We'll have to go back and check.
I appreciate it was considerable time ago.
Yeah. One was, I think, 14 years ago, and the other one was 9 years ago. We can go back and check. They certainly took evidence from the Legal Services Commission, as it was then, but I'd have to go back and check to see what, if any, engagement there was with us.
And I appreciate it was some time ago, and probably those figures are to some extent redundant, maybe if the principles aren't. I think we're going to have to do a piece of work around what the department envisages as a replacement, the time frames around that, and also, for importantly for us, the procedure in terms of the regulations, whether it's going to be a negative resolution or whether it's going to be something that is actually brought to the floor of the House. And that will be important, I think, for us to understand before we agree to anything. A couple of things. I apologise. I have no glasses, so I can hardly see the things I've written down. Please bear with me. Look, the department, I think, is in a difficult position, and it's not for me to defend them. They're well able to defend themselves. But obviously, when there has been a recommendation from the Audit Office and there has been a recommendation from the PAC, it's very difficult for them to just set that aside. So, bearing in mind the issues around, and they have been here and given evidence and said to us that part of the difficulty is, with regard to fees and charges, it's opaque. I think it's opaque and ethereal, even with your paper, and we'll come to that in due course. So, what do you recommend that they do? They can't just ignore it.
No, and nor should they, even if they have for a long time, in the sense that you're seeing a suggested remedy here to a problem that they say has been pressing for 9 years or 14 years. We would acknowledge, firstly, at a very superficial level, there's a degree of opacity around things like taxation and the brief fees that has to do simply with language. So if the taxation master or the taxing master was called the judge who assesses fees, that would be much more straightforward. It wouldn't sound opaque. Brief fees are fixed fees for an amount of work that may expand or decrease with different cases. That's what they are at their heart. But I see that there are, if you drill down into both the PAC document and its predecessor, a lot of the concern relates to predictability.
Yeah.
And that's why I made the point to both Ciara and Deirdre when they raised that issue. We are not resistant to change, but this is a sledgehammer to crack a nut.
Yes, and they've let you down before. And I think that's a question that we also need to put to the department, which is, if you're going to move to this, what guarantees are you going to give with regard to review of fees and indeed of timely payments, because they have not been helpful with that in the past and regular with it either.
The chair would go further and say, I'm afraid the best guarantee you can receive is a statutory obligation to review the scale. That's what they're currently under in relation to Crown Court fees, and they haven't discharged it. So what we would say, and this is again not to sound like a broken record, and why it might be worth speaking to, hearing evidence from the taxing master or the Association of Personal Injury Lawyers or the Association of British Insurers, and ask them about the system in money damages claims, where there is a guide that is followed in most cases, nearly every case, the Cumberton scale, that introduces the key elements of predictability. So you know that if I have a personal injuries case and this is its broad value, the likely amount I will have to pay by way of a brief fee is this figure here on the scale. If you're being sued and you know the broad value of it, you know what your costs liability will broadly be. If someone tries to mark a lot more than that, you can have their fees taxed. So that is a system that introduces a high degree of predictability and budget certainty for all of those bodies in it. We're absolutely not resistant to change. We're willing to explore that, how that type of predictability can be better introduced to other fields. But this is an attempt to deal with a problem that's really to do with predictability and budget by radically altering the entire system. And that's completely disproportionate.
No, I mean,
Sure, if I may, just, I think you asked what should they do. So there must be best practice about how any department responds to Public Accounts Committee recommendation or recommendation for the Audit Office. I would imagine, based on research, that looks like you explore the alternatives, you build the evidence, you evaluate the evidence against each other, and only when, by consensus and evidence building, you have a clear way forward, you move to draft legislation. I suppose our point today is this isn't following that sequence. So no one is saying there is no right for the department to look into this issue, but there's a way it should be done, and there's a sequence in which it should be done.
Yes, that's fair enough, David. I think that point has been well made today, and there are issues that we will take up with the department around that, and timeframes and so on. You know, about reviews and uplifts and so on. Just with regard to the brief fees, then I am going to come upon this because you've made a number of assertions. If I can turn to point 4.6, you say that you talk there about clause 28, and you say in this way members are being asked to vote blind on principle whilst it remains entirely unclear what the alternative methods are, what the time frame is, and how the future systems will recognise time and skill invested by practitioners. But I think to some extent that's already where we are, that we don't know how much time and value is placed on the skill of practitioners. And I earlier on, Donal, when you said we have a certain set of skills, and I smiled because Liam Neeson came to mind.
That's the first time anybody has ever compared me or anything I've said to...
Like, a couple of things that I want to clarify, because it seems to me that sometimes, I want to go through kind of some of the issues that I have with the brief fee. It seems to me that sometimes the fee is calculated on the level of the court as opposed to the hours worked or the complexity of the case. You have cited that there's a difficulty between some of the difficulties around hours worked, because somebody who is vastly experienced will get a case and be able to deal with that in a much shorter time than somebody who is inexperienced. I accept part of that, but I think that's back to the swings and roundabouts, because actually then if there were to be, for you know, a scale of set fees, for example, then actually that would work out to the favour of the more experienced person who will not have to spend hours and hours, you know, if there were a composite fee for that. So let me just work through some of the points before I come to, you know, and you've talked about, you know, experience there, but in some of these cases, the solicitor is actually more experienced than counsel, and yet their fees are vastly lower, a fraction. And you know, they have overheads that don't necessarily apply to the bar, and I think it's important that we bear those things in mind. I also want to check, it was kind of implied around some of this that fees are agreed in advance. Can I check, by and large, are fees for legal aid cases agreed in advance, or are they calculated at the end?
It depends in part upon the case. So quite a few solicitors will ask at the start, what is your brief fee likely to be? Sometimes you can give a pretty definitive answer, and sometimes you have to introduce a number of variables and say it will be between figure A and figure B, depending upon. Some fees aren't decided upon until the end of the case, because quite often because it isn't possible with any degree of accuracy to predict the course the case is going to take. And
you know, I've read your paper and I understand some about refresher
as you
fees
know,
and so on.
Yeah, but it's not even. Sometimes you will start a case, you will receive instructions in something quite complicated, read 4 lever arts files of papers, consult with the people you need to consult with, look at the law. That might be a total of 3 or 4 days work on something very complicated, and you write a very detailed letter of claim. Now all that work will be done by the barrister after the solicitor has had an initial consultation, got the client to get various things together, as you know, and send it to counsel. But at that point there is quite a big baton passing exercise, in that the solicitor will be busy doing something else. The baton passes to you. You may spend a number of full days working very hard on it. You meet the client. You prepare, for example, a pre-action protocol letter if it's a judicial review, or a pre-action protocol letter if it's a commercial action, or whatever. You put your best foot forward in that. That case can either run for a year or 2, the other side fight everything, take all sorts of issues, or what happens sometimes is they receive the letter and 3 weeks later they have come back and said, actually, we want to talk to you, and the case resolves. Now, it's almost impossible to predict which of those 2 courses a case will run at that stage. So it can be very hard to say, I mean, it would be wrong to say my fee is going to be this, because the case could settle and it would be an absolute windfall. So there always has to be a degree of flexibility. But as I've said, the Cumberton scale is a great example of something where you introduce as much predictability as you can, with exceptions. It is also the case, you're absolutely right. Solicitors, the bar and solicitors are two professions that complement each other. You know, we are separate in that there are lots of work solicitors do that we just don't do. We don't do conveyancing, we don't make people's wills, we don't hold client money, we don't employ people individually the way solicitors firms do. We are all individual self-employed members of a library with some economies of scale that come with that. But equally, it's important to recognise we don't have a business with a goodwill that you can pass on. You don't have an interest that sometimes in better economic climates you can sell to somebody else. There are...
We're long past that.
Well...
for some decades.
Yes. They and I know the Law Society have obviously have done a lot of work on that and trying to change.
And that's
things.
why, to be honest, Donald,
But-
that's why we've been keen to hear from you separately, because you're not one kind of amorphous grouping. You know, you've separate and distinct wants and needs.
Yeah, but also overlapping ones.
Yes.
And we recognise that there are some things that are absolutely best done by solicitors, and that we aren't seeking to do or take or encroach upon, and there are other aspects that are best done by us. And you will see, it's absolutely right, you'll be in a case sometimes in the Court of Appeal, say, where your brief fee is 2.5 or 3 times the solicitor's fee, and
Sometimes much higher than that.
quite possibly, but the division of labour at that stage in a particular case, you might be doing 14 times the hours that they're doing on it, depending on the type of case. And you'll have some of my colleagues who will come in to me and say, my brief fee shouldn't be 3 times, it should be a multiple of that. But we have a system here that isn't perfect, that's absolutely right. And you know, we are all for improving it, but we say that's not what this is in any shape or form. And if you look to England and Wales, they have changed their system. We bored you in the Access to Justice Working Group about LASPO and the changes they introduced there, and how one effect of that was to pass a huge amount of work that used to come to the doors of solicitors and barristers onto MPs, and obviously onto you here if those changes occur. But our system, although it is imperfect, is a lot better still than theirs. And one stark example of that is they now have a whole industry in fighting about costs. Barristers, lots of barristers who only deal with disputes about costs in cases. They have complex structures of no win, no fee, and various enhanced fees. Then in that type of situation where you take that risk, defendants paying a lot more in the way of costs. The leading textbook on costs is a book called Cook on Costs. When I came to the bar, it was a book of about 300 pages. It's now more than 1,000 pages. And that's predominantly because of changes to how they pay and how they've assessed legal aid and various other structures they've introduced in England and Wales. And that's just not the road to go down.
That's fair enough. And I mean, there are issues within what they're proposing, and I raised it with the department. You know, this business of will assess on a case-by-case basis, I understand why that's necessary, but how are they going to ensure consistency and so on? So I do have some concerns around that. And with the best one in the world, you know, somebody in the department, you know, who hasn't practiced or who hasn't practiced for some time, how are they going to ascertain the value and the hours necessary and so on? So I get the complexities of the issues. I'm just trying to tease out. Like, I think that there's huge concern around brief fees, and that's why I kind of want to ask you some other bits and pieces. So brief fees are not paid in the county court or the magistrates court. That's right, isn't it?
They're paid in the county court for so if you're for all civil cases and family cases, there's a brief fee. If
There's some places where there are some places where the principle of a brief fee is not applied.
For example, there are some types of work that people will do for an hourly rate and no brief fee.
Yes.
Yeah, that's absolutely right. So, for example, if you were doing a civil case or an inquest or a judicial review or an employment tribunal for the government legal service, you would do that for an hourly rate as a barrister rather than a brief fee?
Well, that actually leads me on, I suppose,
Yeah.
of two questions. One is, why is it applicable? Why is it applicable to have why is a brief fee applicable in some courts and some cases and not others? And the other issue is then, for example, if you mentioned there the government side, if a barrister undertakes a case where there is a brief fee, but is up against, for example, the government on the other side, they don't have a brief fee. So where's the parity in that? And I also, I'm going back to the principle of this is public money, so we need to understand, because these are not small sums of money, don't know all in all. And I am aware of cases, and I don't want to raise those in here because, well, it's identifiable for people, so I don't want to go down that road. But every other service of every kind, wherever you look, it's either a composite fee or an hourly rate or some kind of combination of the two. And I'm not clear and I'm not convinced as to why the bar is different or should be different in either of those cases. So could you deal with those 2 points for me, please?
If you want some reassurance that brief fees aren't a bad thing, look at the Sir Christopher Bellamy review in England and Wales. So that was the English version of the Burgess review. It was in 2021. And
Helpful, thank you.
in absolute short form, brief fees are a good thing, was part of the outcome of his review. They're predictable. They encourage efficiency. A grave risk with hourly rates is they don't encourage people to be efficient with cases. That's a real risk with hourly rates.
Understand that.
Hourly rates are more of a feature of practice at the English bar than they are here, but hourly rates can lead to huge cost in a case as opposed to a fixed, more predictable fee. So that's one example. Another is the Crown Prosecution Service in England and Wales. They chose to keep brief fees rather than hourly rates. So those are two, relatively recently, two recent endorsements of the brief fee principle. But I absolutely accept, I think there's more we need to do to introduce predictability and to educate.
Why a brief fee, not a composite fee? Does that go back to the business of you don't know how things are going to?
I'm not entirely clear what you mean by a composite fee.
I suppose that, a certain type of case in a certain court is going to be roughly, £10,000 or
yes.
£900. Look, I'm also conscious of this, and I want to point this out, because I think it's fair to put it, and it should be on the record. You had cited examples in here of what something might cost. And there's reference, I think, to £10,000 and then £3,000 per day and so on and so on. And my initial reaction was, oh wow, are your words golden? But the other side of that coin, and I am aware of this, is that consultants and accountants, their hourly rate can be the guts of £1,000, £900 an hour. So, and likewise, you also have put in work, training, honed your skills. So what I'm trying to do within all of this is to understand and find the correct balance in terms of fair pay versus public money.
So, you mentioned the potential disparity as well, sometimes between if you have a case where one side, maybe the government, are paying their lawyers on an hourly rate and the other side are going to be able to claim a brief fee, and there could be a disparity. Now, the government legal service or some big clients might decide that we are only going to instruct people who will accept an hourly rate. That's their commercial decision. Sometimes that hourly rate can be high, and it can be the disparity can be in the other direction. It can be the person earning the hourly rate who's earning more than the person receiving the brief fee, and maybe that isn't the sort of story that you hear very often, but that absolutely definitely occurs. If there is a disparity in the other direction, sometimes that can be due to the fact that the hourly rate being paid, for example, by the government, may not have gone up in a long time. So, for example, the government legal service introduced hourly rates instead of brief fees above the county court, so in the High Court and in employment tribunals and inquests in 2012. Those fees have never gone up in that period of time, in spite of obviously quite a lot of inflation since 2012. So that is it's nothing to do with legal aid, happily, but that's an issue. So expressing what the plaintiff not acting for the government gets compared to what the government lawyer gets, the disparity there is probably due in part to the fact that the government rate hasn't gone up. The department or the Directorate of Legal Service, Business Services Organisation, who represent the health service legally, they also have hourly rates and brief fees depending on the type of work a barrister does for them. Their hourly rates have gone up recently, so they're much healthier than the government legal service hourly rates. So
would it be better to have the same principle that applies in all courts? You know, so either there are brief fees in general, or there are not.
To be honest, in a perfect world, if you were designing a system from scratch, maybe you would try to ensure that it's one system. But there are so many moving parts. So, for example, you will have the state can't control what everybody marks. So you will have some clients who will only want to pay on a brief fee system, and you will have others who only want to pay on an hourly rate system.
Sorry, I was just going to come in there to say as well, it goes back to what Donal said at the outset about the potential for a two-tier system also, because it may be that in the ideal world all courts will be the same, but you will only be able to control that in terms of the legal aid fund for those who are legally aided. There will always be people out there, clients who are privately playing throughout the courts, different tiers. So it's very hard to impose a single uniform standard, because you're never going to be able to bind what private clients will pay their lawyers. And inevitably then what we will find is that those who are willing to pay privately are able to access the best, most experienced, diverse group of lawyers. And there is a real risk then that
justice becomes the privilege of the wealthy.
Absolutely.
Yes.
Yeah, access to justice just becomes a slogan. You know,
Yes.
nothing more.
Look, it's been really good. You've been very generous with your time. I'm grateful to you for. It's important for us to tease out some of these issues and to understand kind of all of the facets of the arguments. So thank you very much for that. Does any member have anything further? No, you're content. Could I thank each of you very much for your time today? We'll follow up with you with regard to a meeting on the other issue.
Absolutely, and as I say, we'll send you through some of those documents we mentioned, but if they give rise to any questions or requests for other documents, please let us know, and we will see you again at some point in the near future about the other issue.
Thank you very much indeed.
Thank you.
Thanks, Donald. Thank you, Denise, David also. Thank you. Right. Just a bit of housekeeping. Get Bill stuff to the side. Thank you, Mark, because I feel like I've really been up here.
Yeah, sorry, I closed the window and I was sitting during that thinking I'm far too warm now, so apologies.
No, it's impossible to regulate, Connie. All right.
Sorry.
Sinead, thank you very much.
See you again.
Members, agenda item 6 is the draft budget, which is oral evidence from the department. Can I ask you to turn to pages 56 to 133? I'm sorry that we've overrun a bit in terms of time, but I think it was important to understand some of those difficult issues, especially given the circumstances we're in present. Also, can I ask you to turn to pages 3 to 21 of your tabled pack. And I would ask you to note that the title for item 6.3, well, that's up for me or for the members.
You do both actually, yeah.
It's dated the 28th of November 2024, but it should be the 9th of January 2025. So members, we have departmental officials with us to provide oral evidence on the draft budget. and I would welcome Deborah Brown, the Director of the Justice Delivery Directorate, Richard Logan, Head of Financial Services, and Andrea Quayle, who's Head of Financial Planning and Strategy. Folks, thank you very much. Thank you for bearing with us in terms of time. We were taking evidence on the bill, so you'll appreciate that's quite important for us as well. That's our work priority at the minute. But thank you for bearing with us, and thank you for taking the time to come and give us your evidence today. I'm going to hand over to you to give us your opening remarks, and then we'll move into questions if that's all right.
Thank you very much. So good afternoon, and thank you for the opportunity to update the committee on the Department's draft 25-26 budget. So as you say, I'm joined this afternoon by Richard Logan, our Finance Director, and by Andrea Quayle, our Head of Financial Planning and Strategy. We've already provided the committee with a written briefing on the draft budget outcome, and Richard will shortly provide a brief overview of this. Before doing so, I'd like to make some observations on the budgetary challenges facing the DOJ for the coming year. After providing for earmarked items, the Executive had just under $1.3 billion of funding available to meet pressures of almost $4.7 billion across all departments. The Department of Justice received a general allocation of $132.3 million, which represents 10.5% of the funding that was available to the Executive. This is a favourable outcome for the Department when compared with our previous budget settlements. Whilst the $132.3 million is welcomed, it must be considered within the context that the Department has faced years of underinvestment, something that the committee is well aware of. It remains concerning that the DOJ share of the block has fallen continually over the last 14 years, from just under 11% in 11-12 to just only 8% in 25-26. At this stage, we're currently forecasting that the Department will live within its budget in 24-25, but that result will still require continued strong financial and operational management over the next couple of months. The draft budget for 25-26 will go some way to alleviating the significant pressures currently being experienced across the justice system. However, despite that additional allocation of $132.3 million, the Department is still facing $60 million of stabilisation pressures going into next year. There are competing pressures in all areas within justice, and there is minimal scope, if any, to reduce or divert resources from one critical area to another, given that the service delivered are all deemed to be departmental priorities and are interdependent. Additional funding is still needed to sustain current services and meet the increasing demands in areas such as policing, legal aid and prisons. However, given the significant level of pressures across the Northern Ireland bloc, it is likely that there will be very limited, if any, additional funding available for reallocation in 25-26. The Department's shortfall of $60 million will present challenges across all our business areas, including legal aid, policing and delivery against the Programme for Government and our business plan. Difficult decisions on prioritisation and service provision will therefore be required across the Department and its non-departmental public bodies to manage these remaining pressures in order to live within that draft allocation. Business areas have been asked to provide a high-level update on their assessment of the budget impacts as part of the draft budget allocations that were issued on the 29th of January, along with their updated equality impact assessments. This information then will be provided to the Minister to inform finalisation of allocations and consider the potential actions that could be taken to reduce that $60 million gap. In addition, further discussions will be needed with the Executive and the Department of Finance to consider the options for funding the exceptional pressures of $227 million for the legal claims. The previous Finance Minister had indicated that it was her view that these items are unaffordable within the existing Executive bloc, and therefore it was her intention to explore the potential for making a reserve claim to HM Treasury, and we hope this will continue to be supported by the new Finance Minister. You will appreciate, therefore, that this is a challenging budget for the Department and will require very careful management and difficult decisions to reduce the risk of an overspend. So I'll now pass across to Richard, who will give you some more information.
Thank you, Deborah. Thank you, Committee. I just intend to provide a brief overview of the draft budget position, which has already been detailed in the briefing paper shared with the Committee ahead of today's session. The Finance Minister issued budget allocations to departments on the 19th of December 24. The department's non-ring-fenced resource-style budget included an additional general allocation of $132.3 million, which equates to the 10% of the total funding available to the Executive. We had to make a number of assumptions and considered various options for allocating this additional money across our business areas. The Minister was very clear that the allocation should be based on the most equitable and fair basis for all our organisations, and that's particularly important for the justice system, given the consequential impact that funding decisions in one area may have in other areas of the department. At the previous finance update for the committee on the 12th of December, there was a discussion regarding the potential impact on service delivery in a worst-case funding scenario. Thankfully, we are not in that position, as the draft budget outcome was more favourable than that scenario. However, there are still significant pressures, and we were very mindful of the potential impact on services when considering budget allocations. A pro-rata allocation based on inescapable stabilisation pressures was ultimately determined as the option which provided the most equitable distribution of the available funding across our core department, agencies and NDPBs. And this option is consistent with the approach we took in 24-25 and was approved by the Minister. The opening budget allocations were then communicated to our business areas on the 29th of January. Whilst the additional $132 million of funding is welcomed, it still leaves the department facing stabilisation pressures of approximately $60 million going into next year. This consists of the £34 million remaining from the $207 million pressures initially reported to DOF in October 2024, and in addition there's been $26 million of new pressures that have since emerged relating to increases in employers' national insurance contributions, revised NICS pay award assumptions, and increases to legal aid fees recommended by the Burgess report. It is reasonable to assume that some additional funding will be received by the department in due course for the costs of increased employer national insurance, Windsor framework and technical transfers. However, these amounts have not yet been confirmed by DOF, Treasury or other departments, and in any event they are unlikely to cover the full costs involved. Former Finance Minister previously stated, given the Chancellor's autumn budget and spending review now resets the funding envelopes for Whitehall departments, that Northern Ireland departments cannot expect the same levels of additional funding to be provided in year during 25-26 as was the case in 24-25. Furthermore, given the significant level of pressures across the bloc, where the bids for all departments were approximately $3.4 billion more than the funding available, it's likely to be very limited, if any, funding available for reallocation during 25-26 in the monitoring rounds. So the department and its business areas are currently considering what actions are required to live within the resource budget allocation as it falls short of what is required, and Deborah's mentioned difficult decisions will still be required. And as a result, all DOJ business areas, though, will be required to implement cost reductions and efficiencies in order to reduce the level of remaining pressures. In terms of capital, the department's DEL allocation was £100 million, a shortfall of £35 million or 25% against our total revised bids of £135 million for inescapable, high priority and desirable projects. The Minister approved the allocation option, which met 100% of the inescapable bids, provided an allocation to the prison service equivalent to its average capital expenditure over the last 4 years, and allocated the £17 million remaining balance to the high priority bids across all areas. So in closing, I trust we've provided you with a helpful but candid overview of where we are now in terms of our financial position. While we continue to operate in an uncertain financial environment, the department's position remains extremely challenging in terms of managing our budget. I'd like to thank you for the opportunity to brief you today. We very much value your role and the views of the committee, and we're happy to take questions.
Thank you very much, Richard. Yes, well done, living within budget in what was a very tough year, but obviously it's not going to get any easier when you look at next year's. So, members, I'm going to open the floor to you. Have I got anybody? Doug.
Thank you, Chair. It's just a brief one. Can I just ask where we're sitting at the moment with the PSNI's bid for business case and bid for 200 million for additional recruiting and the recruiting campaign? Where's that sitting at the minute?
So we're nearing finalisation of that business case, and we've been engaging with DOF with a view to get the business case to DOF for approval. With regard to the in-year position, as you're aware, PSNI have started to recruit, but there's still pressures that PSNI are facing, but they will continue with the recruitment campaign. That's just about replacing officers at this stage. So that is not prejudiced by the business case that is needed. The business case clearly sets out a need to increase police numbers over the next year to 7,000. We've had very good feedback from DOF on the business case, but of course it has to go through the approval processes. And then of course we will need to come to the executive about the future funding to making sure that we are able to fund the existing police service and then grow it towards the 7,000.
Do you have a rough time frame for that? Sorry, I don't want to put you in package, but do we have a rough time frame for that on whether or not we get agreement or not on the business case?
We're hoping to get the business case to the DOF in the next couple of weeks.
Good enough. Thank you. Thanks, Chair.
Thanks, Doug. Justin.
Thanks, Chair. Thanks, folks. To what extent are you taking into consideration the draft programme for government and the objectives of the Enabling Access to Justice Reform programme, with acknowledging the actions that potentially will need to be taken as a consequence of budgetary constraints?
So there is an exercise that has been commissioned by DOF around mapping budget to programme for government. So we are currently taking that forward, but of course programme for government does not cover everything that the department does. The Safer Communities priority within programme for government is not just being delivered by the Department of Justice, but we have a number of initiatives that will contribute towards that. And in addition to that, we have a number of transformation bids which would also help to deliver on the Safer Communities initiative, and we still await outcome on the 3 bids that we have put forward. So we are aligning with programme for government. We are discussing you have got our draft business plan, and we are now considering our corporate plan for the next 3 years to align ourselves properly with programme for government and the priorities of the Minister.
And we'd expect then, now that the draft allocations have been shared with business areas, they'll give them time to now to look at their pressures, because the pressures we're talking about now were submitted to us back in September 2024. So they're 4 or 5 months out of date now. So the business areas need to look at their allocations and also their latest pressures, and then see what impact, be it on priorities, PFG, etc. And we'll see that maybe hopefully whenever we get their feedback on the impact of the draft budgets we've issued to them.
Okay, thanks, Deborah, Richard, and Andrea. Thanks, Million. Thanks, Chair.
Okay, Justin, thank you. Does anybody else have anything? Deirdre?
Yeah, no, thanks very much for the update. And obviously, I mean, it's an improvement, in terms of it's moving in the right direction, and hopefully you'll still have that same positive engagement with the new Minister. I suppose just on a couple of things, is if there's any more update on the reserve claim that you have at this point. You'd say around the gap and pressures around 60 million, and again we still have to see the outcome of the national insurance contributions and what Treasury say in terms of that. But how much risk are you willing to manage getting into the next financial year in the budget? And the other query I had was around I suppose the focus from the Minister, and rightly so, in terms of domestic violence and tackling violence against women and girls. And obviously that's one of the areas that you address budgetary concerns. So just as that part of that prioritisation process, will this work form part of that in terms of the Minister's considerations? Because I think there's been a lot of good work done in highlighting the issue, and I think for that then to drop due to the budget would be very concerning. So it's just to try and get some assurances around that as well.
Yes, certainly in terms of the reserve claim, my understanding is DOF will wait probably until the new financial year to see what the total reserve claim is, rather than and looking to see, because the issues we have in reserve claim, it's data breach, holiday pay, and McLeod injury to feelings. Data breach is only one specific to DOJ, the other ones are across the block. Right. So I think the intention is DOF and the Minister will be going on it as a collective basis of saying here's the total ask, rather than piecemeal at various stages. Certainly in terms of the Minister's priorities, the ending violence against women and girls, there were bids and pressures put in that we took into account, and the funding was allocated to that to allow sort of a range of options or work to be done to take that forward. So that will be addressed by the funding that's been allocated out, not in full, but it's certainly been included as part of that.
Okay. And just the kind of level of risk that you're willing to, in terms of getting into the next budgetary period, what?
There's a bit of, we know business, now they've got their budgets, we know that there will be, they have to make cost reductions and savings. If everybody, the total budget of 1.4 billion as a department, if there was 1% efficiency or cost reductions, that's equivalent to £14 million. So if everybody was able to identify 1%, if we got some money for the employers, and I say if we got half or 2/3, that chips away at the 60 million. We're still waiting for money for the protocol and some money, and whether or not there's money for the NICS pay award. So there's a number of different possible sources of either additional income or cost reductions that we hope will bridge the gap. We still have them within place, and we met with them on Monday. They'll take the figures away and work through what that means for them, just in terms of recruitment to maintain their numbers and then the additional numbers. So the gaps will be narrowed. It's just trying to see from this next phase what the revised gap actually is, and that will influence and then sort of influence our decision in terms of the risk then we take from that point.
Okay, thank you.
You wanted in?
Yeah, and obviously it is quite deeply concerning in relation to not funding projects aimed at tackling domestic abuse, as my party colleague has mentioned. We're also aware of the pressures on legal aid, the delays in paying bills, the need for the Burgess uplift to be implemented, and the impact this is having on the legal profession, local people and access to justice. Can you clarify what assessment has been done on the impact this would have, particularly in relation to the budget allocation we'll have in the payment of legal aid and the planned uplift?
Okay, so maybe if I could just cover generally where we've got to in legal aid, because I do believe that there is a good news story in here. So if we just look at how the legal aid baseline has grown, so since 1920 year, the baseline has grown from 76.9 million to what is now has been allocated for 25-26, which is almost 120 million. So that's an increase of nearly £43 million over that period of time, which is a 55% increase. On spend has grown from 82 million in 1920 to approximately 118 million that we intend to spend.
You're saying 1920?
Yes, the year 2019, 2020.
The
financial year. Sorry.
100 years ago.
No, not 100 years ago.
Go back. Well,
Sorry.
103 years.
Quite the sum then.
So the financial year 1920.
Yes,
yeah.
sorry, apologies.
So you're talking the 5 years.
Yes.
Yeah.
So the spend has grown from 82 million to an anticipated spend this year of 118 million pounds. Last year was 114. So we continue to secure additional funding for legal aid, and we continue to make the payments and get them out the door. That means that the backlog that we had at the end of last year of nearly 20 million, which is about 11 to 12 weeks, should reduce by the end of this year to about between 11 to 14 million, which is 6 to 8 weeks. If our demand next year is 115 million, against that allocation of 120, that would allow us to make further inroads into that backlog and could bring us back closer to the 4 or 5 weeks. Caveat on that is the impact of the Burgess increases. So you'll see in your paper that we've estimated the implementation of the Burgess increase of 16% from May, which is the point in time where we expect to have all of our approvals in place, and we have our legislation in place, and we start paying up by about £6.5 million. And if you think that this year our demand, has dropped, demand is about 111, 112. So whilst we're putting more money out, that's clearing backlog. Yeah. 111 plus the 6, it shouldn't have a massive impact, but of course we will ask for further funding throughout 25-26. But it will have an impact, of course. But I think that the good news here is that the agency continues to make significant inroads into reducing the payments. On the withdrawal of services in January and now continuing into February, we don't know what impact that's going to have next year. Whether that pushes costs further out or whether you will have a big catch-up in 25-26 which then would increase demand, we don't know. But Paul Andrews is an absolute master of being able to do all the scenario planning and his projections and different things that he needs to do. So you'll be assured that he'll be on top of this. But 25-26 is presenting new challenges to us because of the withdrawal of services and also then the implementation of some of the recommendations in Burgess, which includes the 16% uplift.
So you're basically saying we need to be a bit cautious because with the withdrawal,
Yes.
that could go on, if it's pushed back, it could be going into the next financial year. So though at the moment, there could be some good news in cutting the delays and being able to cover the 16% in May, given the decrease in demand. It's being cautious around the following financial year. You're just
Yeah, so again, every time we think we're getting ahead of the game, legal aid or making inroads, then we'll have something else come to left of field. So the Burgess review, we knew that there were recommendations coming out that we need to consider. The strike was, the withdrawal of services was something that we thought that we could have prevented, but unfortunately, despite best efforts and negotiations and engagement at length over the past number of months, that hasn't been possible.
Thank you.
Peter, you wanted in the point?
Just a brief one on the budget stuff and national insurance, and obviously more for voluntary and community organisations that are funded by the department, and obviously Treasury are already saying they won't extend support for that. But are you looking at the scale of what that would look like for those organisations, the potential risk for jobs or, cuts in hours and stuff or redundancies? And are you looking to offer flexibility in the grants to maybe allow some of those pressures to be absorbed within the existing grants that are given out? So it's just to try and get a sense of the impact that this would have in terms of those providers working on behalf of the justice system.
With our engagement with those organisations, we only have maybe say a snapshot of their costs that relate to our projects or programmes, so we don't know their overall pressure. But based on what the costs are coming in for the core agencies and NDPBs, it's probably about say a 1 or 2% increase in costs overall, and we pay out probably about in the region of about £7 million or so to voluntary community. So you're maybe talking about 100,000, couple 100,000, but we don't know if those are actual costs because it may not all be salaries, may not be fully affected. So I think we'll see what funding we get, and then it'll be probably down to the individual business areas within the department that engage with the voluntary community sector to see what their pressures are and deal with that on a case by case basis.
But is there alert to it then
we
in terms of looking at that as well?
aware,
Okay.
And that is sort of 1 to 2% is roughly
Right,
the
scale.
cost that it would be.
Okay.
And we have always taken the approach in the allocations to the voluntary community sector where they deliver and help us deliver our core services. We've always tried to minimise the impact on them because we know we couldn't deliver without them.
Thank you.
I just have a couple of folks that I can race through fairly quickly. I'd like if you could give us a timeline for when you anticipate decisions around the transformation bids. If you could tell us, there's a lot of risk here in terms of services that may be cut. If you could tell us how you're going to prioritise those and sort that out. And in your documentation there, paragraph 8 of the paper that you provided us, the Minister has gone for option 1, which is a pro rata allocation to business areas based on inescapable stabilisation pressures. That's fair enough, you've gone with inescapable, but how are you going to tie that in with the prioritisation, with the priorities that have been identified?
There's a couple of points. Sorry, on the transformation, we don't know what the time frame is going to be. We're subject to the executive making a final decision, and then Northern Ireland Office and Treasury have involvement in terms of approving that. So there's a few stages still to go through. So we just have to wait and see. So we can't be definitive on what the timeline will be. In terms of the service cuts, I think we'll be better placed to answer that when we get responses from the business areas in terms of what the budget, what the impact. Now that they've got their allocations and they can refresh their pressures to see what changes or reductions they have to make. So we'll wait for feedback from them to see then what that's going to be. And paragraph 8, sorry, just was on the inescapable.
Your non-ring fence resource, Dale.
Yeah, I suppose the high priority and the desirable pressures were relatively minimal, that maybe only about 3 to 4 million of the total 200 million. There were reports something in that region. So some of those maybe have already dropped off, or some of the things that maybe were deemed to be inescapable hopefully will come in at a lower cost, which will allow other high priority ones to be undertaken by the businesses. So and that's why we're waiting to see what they come back with, and then we can make an assessment in terms of sort of the risk to the overall provision of services.
Okay, and what's the time frame for that?
We've asked for business areas to come back by a couple of dates in February. 14th of February is in terms of equality impacts returns coming in. 17th of February is the organisations coming back with their overall impact. So that'll give us an opportunity to look at that stage. And then that leads into the DOF consultation finishing on the 13th of March. So we have that bit of time just to sort of see and assess before budgets are actually finalised.
That's helpful, because when you consider some of the services that may be cut and some of the impacts, I mean, it's not a pleasant picture, that's for sure. It's certainly enough to keep you up at night. Just one last one, which is you were anticipating a pay increase for the civil service of 3%, and that's going to be 6%. What's the figure there, and is that going to be, how is it going to be found?
Well, the figure will be somewhere between £4 and £5 million between the core department, our agencies and NDPBs, because a lot of our NDPBs, their staff are aligned to NICS terms and conditions, so the police civilian staff are police ombudsman, policing board, so it's not just the core department this impacts, it's across the wider. At the moment we need to see maybe what funding will come from the executive in terms of allocating that out. I think they had set some, the intention was to set some aside, but I'm not sure whether that covered core department agencies only or the wider public sector, so we need to see from what allocation, and that's what we talk about in terms of saying it's reasonable to assume we will get other allocations in the course of the year, but we just don't know the quantum. But if we get half of what our pressure is, won't solve it all, but it will certainly bridge that gap. And I think that's probably going to be maybe the approach for a lot of this, that we're not going to get one large amount in the monitoring round to clear the pressures. It's a case of looking across a number of different options and reducing slightly in one area and another area, that the cumulative effect takes us to bridge that overall gap, rather than necessarily just one big large cut in one particular area. I think it'll be a series of just a combination of different smaller hopefully impacts for people.
Understood. One last question, which is around, the issues about McLeod and those three kind of issues that the department just can't meet. The longer that goes on, is the likelihood that the sums will increase?
I don't think necessarily. I know there are ongoing discussions and conversations with each of those cases to try to resolve any outstanding issues, but at this stage I think the final solution of answer would still be the same, whether it's resolved today or in 6 months time.
That's fair enough. Thank you very much. Does anybody have anything else? No? Well, then that's lovely. Folks, thanks so much for your time today. Greatly appreciated. Thank you. And for the papers that you provided for us. Thank you. Members, any further responses that we receive from the non-departmental public bodies will be included in our papers for next week's meeting. So I'm going to ask you if you would consider the key issues you want to include in our response to the Committee for Finance in advance of next week's meeting, because that will enable committee staff to prepare a draft response for consideration at our meeting on the 27th of February. So do people have views on this? About the key considerations that you want, sent through to Committee for Finance? Well, has anybody got, I suppose anything you've got we could email in to the clerk, but is there anything that's striking anybody now?
In terms of the budget, sorry?
Obviously we've got to report our views on the budget to the Committee for Finance so they can take it into account. Is there anything we particularly want to highlight?
It's just the issues around the reserve claim, because that will have a big implication, so just clarity when we can, the national insurance contributions. Obviously Westminster still hasn't given clarity on a figure, and I just know from the last finance minister they said for executive departments alone is 200 million, and we won't get all of that. So that doesn't include arm's length bodies and others. So it's still a concern. We still don't have a full picture in terms of the budget implications, I suppose, is the point I'm making, until we get clarity around some of those issues.
Okay, that's fair enough. Kathy, do you want?
Yeah, and Chair, I was just going to say that we can use obviously the discussion today and previous discussion, because I know that some of these issues would have been raised before, and draw out the key issues that were discussed then for inclusion in a draft response.
Yeah, to be honest, in terms of the justice budget, I don't think that the conversation changes greatly from time to time. It's always the same issues, you know. So right, that's fair enough. I'm conscious of time, members, so we'll move on. Agenda item 7 then is the Justice Bill and written papers from the department, and that's item 7.1 and 7.2. I'd refer members to pages 135 to 151 of the pack for the relevant papers. So this is correspondence from the Department of Justice providing the updated text for the proposed live links, court and tribunals amendments to the Justice Bill, and a copy of the draft amendment text. Could I seek your agreement to note these papers from the department first of all? Agreed?
Yeah.
And just remind you that as we agreed previously that all of these papers would be published on the committee's webpage. Agreed?
Agreed.
The one thing that I would like to check now is, in theory, that's everything that the department had planned to bring. Could I request that we would write to the department and ask, okay, well, now that you're complete, can we have some indication as to when you intend to formally table those amendments? Because we have those in theory, but they also haven't been tabled yet, so they're not official. Could we try and establish, because I suppose the concern there would be, whilst that's what their intention is just now, that doesn't mean that they wouldn't be subject to change. So are members content that we do that?
Yep.
That's great, thank you. Item 7.3 then, I would ask you to turn to pages 152 to 164 of your pack. This is correspondence from the department which provides follow-up information that the officials agreed to provide during the oral evidence on amendments to the bill on the 16th of January, and this includes information on human rights consideration in respect of the department's proposed amendments, the restorative justice accreditation procedure, how the Proceeds of Crime Act 2002 deals with legacy issues, and access NI filtering and equal protection for all children and young people. Are members content to note the department's response on these matters? Do you require any further information, or is there anything else you want to raise on those? No, I suppose I still have some concerns around the robustness of the accreditation process and how they can filter out people who are unsavoury. I'm not convinced that it's as robust as it might be around those, but that's my own view. Agenda item 8 then is SR 2025-4, and that's Rules of the Court of Judicature, Northern Ireland Amendment 2025. That's page 165. Members, you'll remember that this rule is going to amend the Court of Judicature rules to facilitate, alongside UK-wide regulations made by Parliament, the implementation of the Hague 2019 Convention on the Recognition and Enforcement of Foreign Judgments in Civil and Commercial Matters. The rule also amends the COJ rules to make technical changes to the current procedure for recognition and enforcement of foreign judgments under the 2005 Hague Convention on Choice of Court Agreements cases to ensure consistency with the procedure to be followed for Hague 2019. The rule is subject to the negative regulation procedure, so it wouldn't come before the House unless we decided to pray against it. I would advise members that the Examiner for Statutory Rule has raised no concerns regarding the technical aspects of the rule in her report that was published on the 27th of January. Also, just a reminder that we agreed that we were content with the proposal for the rule at our meeting on the 30th of May 2024. Now, there's some water under the bridge since then, but the Department has confirmed that there's been no change to the policy content since that SL1 was considered by the committee. Are members content with the statutory rule?
Agreed.
Yes. Right, if members are content, then I'm going to put the question. And the question is that the Committee for Justice considered SR 2025 number 4, the Rules of the Court of Judicature Northern Ireland Amendment 2025, and has no objection to the rule. Are members agreed?
Agreed.
Thank you. Agenda item 9 is a review of the Policing Board. the report on that. That's page 188 of your pack. So this is the report of the review of the Northern Ireland Policing Board, which was submitted to the Minister of Justice on the 20th of January. And the report was circulated to you by email on the 29th in advance of its publication on the 30th. It's now in the public domain. Do members have any comments they want to make or any issues they want to raise around that?
I suppose just, Chair, sorry, I know last week we kind of held it because we'd only received it and it was obviously an extensive enough report, and obviously we were going to await judgment and to see if the Minister was going to make anything. So I know she has said she's going to reserve judgment until the Policing Board primarily and stuff look at it. So I would be content enough. It's primarily a Policing Board issue, albeit there's other things that need to be looked at, but happy to wait and see what the Minister and the Board say in due course.
Well, that's fair enough. The officials here had recommended maybe we would ask the Minister for a response to the report and her plans to address recommendations when they're available. And probably along with that, I wouldn't mind hearing what the Policing Board's response is. Yeah. I think we don't want to tread on their toes, but we need to understand where they're coming from too. My personal view of it was some of the recommendations seem fair enough, and others perhaps not so easy to implement. But Doug, I see your hand up there. Thanks.
Yeah, and I kind of agree with you. I think I would like a response from the Minister in regards to this. I mean, part of the report talks about the tripartite arrangements between the various different groups. And that certainly involves the Minister and the Department for Justice. So it would be worthwhile to sort of get their views and feelings on that and how do they go forward, and when we're likely to see a report coming from DOJ on how they're going to deal with some of the issues which affect them in regards to this report.
That's fair enough. So I think we can do that. Would members also be interested in hearing from the Policing Board, whether, even in writing, to see what their initial response is, or...
Yeah, I think an update from them too.
Yeah, an update from them too.
When it's available.
So are members content with that we get an update from the Department and the Board? Lovely, thank you. Agenda item 10 is correspondence. There's correspondence memo and 11 items of correspondence at pages 254 to 308 of the pack. So I'm going to draw your attention to one of the items and then I'll open the floor as usual for comment on anything else of import or particular interest to you. So item 10.11 is correspondence from McGibbon Consultancy and Safeguarding Services, confirming that the correspondent is indeed happy for our committee to share his correspondence with the Department of Health and the Committee for Health. So that's great news. The correspondent has also provided a further item of correspondence that he received from the Minister of Justice. Just want to remind you that at our meeting on the 23rd of January, we had asked the Department for further detailed information regarding the proposed review of the case that Mr McGibbon referred to in his correspondence and is awaiting a response. So could I ask you to note that correspondence in the meantime, please?
Noted.
Thank you. I'm going to open the floor if anybody has anything else they want to raise in correspondence. Ciara?
Yeah, it's in relation to the individual formal complaint that came in through an email. It's on page 297.
It was on my list too.
Yeah, I would just like to note that I am aware of the individual. I have met with the individual in the context of with a number of other women in the city over the last year in relation to the issues that have been addressed in this letter, particularly in relation to judicial handling of domestic abuse cases, and then secondly in relation to the family courts. So I'm wondering, I would like to propose that we get, in the first instance at this stage, even a departmental response to the issues raised, if that's something that members would agree in the first instance.
I'm glad you raised this, Ciara, because I had intended to raise it. I'm concerned about this, and members will note that this is not just coming to our committee, but certainly I am receiving a number of emails, not specific to this case, but around the general theme of some of these issues. I was not, in my ignorance of all justice issues, I'm still learning some of this, but I was not aware that it was a judicial ombudsman. I'm not clear what the role is of the judicial ombudsman. I would have some concerns that the department will come back and say that's an issue for the judiciary, it's an issue for them, and they'll not necessarily give us any information, but I don't think that precludes us from trying. So, yes, I would like us to see what they say, but I'm wondering about the merits also of writing to the Judicial Ombudsman, closing this complaint, and perhaps understanding whether or not it is their intention to investigate, and if that is their intention, perhaps a timeline or some kind of indicative timeline, and express our interest in seeing what the outcomes might be and what the findings might be, because we are all MLAs, not just those of us involved with the Justice Committee. We are all receiving correspondence on these issues, and there are serious issues in there too. I would also like to tease out from members their feeling about whether or not we seek the views of the Lady Chief Justice on this. But I am conscious that there's reference to her within the correspondence. Anybody, any views?
I would
on
agree.
that?
I would, in principle, we could at least seek to speak with the Lady Chief Justice on the issues
Seek her
raised.
view, maybe.
Seek her view.
Something I've been contacted about as well, and then not by this individual but by others, and it's, it does seem there's not a lot of transparency when it comes to family courts, in my view, and I think more information we can get as a committee I would be happy with, and I would appreciate the views of Lady Chief Justice.
And I have in the past raised issues with the likes of when I do visits to courthouses and stuff, I've raised it with the recorders within courts, these pertinent issues, and it's just not this individual, other woman have come through my office, like many other women, raising similar concerns. So it needs to be looked at, unpacked, and we need to see what can be done to support women and children.
I think we need, and this is where we need to allow due process to take its course, but I think we need to understand, okay, well, these issues have been raised, so what's being done to look into them, address them, or consider them? So are members content with all of those approaches that we find out from the department, find out from the Judicial Ombudsman, and find out from the Lady Chief Justice?
Yep.
That's great, thank you. Content to note everything else?
Noted.
Thank you. Agenda item 11 then is the forward work programme. So an updated forward work programme is at pages 310 to 317. A couple of things. First of all, the examiner's statutory rules has been provisionally scheduled to provide advice on the delegated powers in the department's proposed amendments to the Justice Bill on the 6th of March. Can we agree to formally request this advice? We haven't done that yet. Members agreed?
Agreed.
Thank you. Now, the other thing is this. The Solicitors and Criminal Bar Association have contacted us to say they're actually not ready to give evidence on the bill yet. So they want a delay. So first of all, are members content to reschedule that?
Yeah, great.
Secondly, obviously within that period, the bar has come back to say they would like to come and speak to us with regards to access to justice reform programme. I think it would be helpful to see. The Minister had made reference in the Chamber on Monday that she was going to be having meetings on Tuesday with the profession. So it may well be that next week is too quick for them. It may not. They may be ready to come and just kind of share with us where they are. Some of them may prefer for the conversations to continue before they'd come and engage with us. But can we seek to... I'm conscious that time is progressing and we don't want to waste committee meetings that we have. Can we seek those options, maybe to have a conversation around the Access to Justice programme with the bar, the Law Society and the Solicitors Criminal Bar Association? If people want to avail of it, great. If they can't next week, I think there's still an important conversation to be had there. But we'll figure something out because we need to be progressing with our work.
Great.
Yeah. That affords us a degree of flexibility then with the forward work programme. So members are content to agree that programme. Doug, are you waving at me?
No, I was waving at a child that just walked past.
Oh, right, okay. Okay. I was terrified in case you were desperately trying to get my attention. That's fair enough. Right. We're all agreed, and we'll allow a degree of flexibility then that we can try and schedule in something for next week to make sure that we're not losing time. Okay, members content?
Yeah.
Thank you. Agenda item 12 is chairperson's business, of which there is none. Agenda item 13 is any other business. Does anybody have any other business? No. Just once again, Gemma, thanks very much for your service here, and we wish you well and wherever you're headed next.
I'm going to the Finance Committee, Chair, so
Ooh,
I'd fry and pan into the fire.
on times. Right. On that basis then, agenda item 14 is date, time, place of next meeting, and that's going to be next week, Thursday the 13th of February, 2 p.m. in this room. The meeting is adjourned. Thank you, everybody.
Thank you.
Committee Room 30. Sound. Committee Room 30. Sound.